Okay, Hun-Medipharma. So let's go back to the Income Tax Act now and talk about that definition. Of SR&ED in the Act itself. So what happened here was that the client analyzed, and again, this was an informal procedure, so they limited it to $12,000 so they could get it through very quickly. And they analyzed a drug that was available for Europe for 3 potential applications to the North American market, and at the end concluded that they couldn't use it. And the CLA argued that you didn't go far enough on the project because you didn't do any clinical trials. You just analyzed different alternatives and made a conclusion. Okay? So they went to court on that basis. Now, when you go to court, the judge doesn't read CLA ITs or ICs, right? What do they read? Anybody? There's only one thing they look at. Income Tax Act, yeah. Right? And the technical notes to the Act, which is, in plain layman's terms, when they explain this legislation to our elected officials that passed it, because most of those guys aren't lawyers, you know, if you read the tax code to them, they're not going to understand it. What they do is in plain English. It's called technical notes, Department of Finance technical notes. I use these all the time. They write out, I say in terms even a politician can understand, what's the problem, what's this legislation intending to do, and why should they vote for it? And then they yay or nay it till they get royal assent. Once it goes through. And what I use is I read those technical notes all the time. That overrules any IT or IC. If I can go into court and say, look, this is what they told our elected officials when they passed it. This is exactly my client's situation. They're following what was intended by the law. And CLA's got a different interpretation. I don't care. And the judge doesn't either. The judge is going to say, no, our elected officials intended this client to get it. CLA must follow the rules. All right? So what happens here is the judge said, well, I don't know how to rule on this. Let's see what the Income Tax Act says. So it says, systematic investigation or search in field of science and technology by means of experiment or analysis. And he stopped right there. And he said, well, when our elected officials passed that law, they didn't make a mistake when they put the terms or. They didn't mean an analysis, but they put or by accident. No, they meant or analysis, and it said experimentation or analysis, and you clearly analyzed 3 different alternatives. So you clearly qualify. The judge says it didn't say experimentation, analysis, and clinical trials in the Act. If it did, well, then you would have been, but it doesn't even mention clinical trials in the Act. I'm saying CLA made up that rule. CLA created its own rules that we think, in this case, you should have clinical trials. But it's not in the Act. So he says that CLA has no authority to make its own rules. Okay? They have to follow the rules in the Act. All right. So again, understanding the Act. If I analyze alternatives according to the Act and make conclusions, as long as I got all the components of the project, I should be in. All right. Pulling to the end of the technical projects now. RAS Christie is one of my favorite ones. Just that it illustrates almost everything that we've been talking about. All right. So RAS Christie is a very interesting case, in my opinion. It was a claimant in Ottawa, and there was basically a small company with 2 main participants or partners. One was an engineer who was a technology guy, who did all the SR&ED, and the other was the financial accountant guy. So, basically what happens is they go to court and they developed a patented concrete forming method. Okay? And when the CLA reviewer comes in, he says, okay, that's great, but they claim a little over a man-year of work to do, all the experimentation, man-year of time. And he says, okay, well, what did you do for the whole year? Like, what kind of experiments did you do, and how did you spend all that time? He said that the client provided 38 pages of documentation, which looked like 1 page of rough notes, and 1 test which went right to the final solution, which he thought might have been 1 to 2 days of work. Very much like a phonograph, okay? These guys had a brilliant idea. They're smart guys. And within a day or 2, they patented it. Okay? But then what they did is they said, why should we be punished for being so brilliant? Someone lesser than us probably would have spent a year to do this, and therefore we should be able to claim our costs for a full year, even though we didn't actually do any experimentation. This is what I think happened. Now, they've never admitted to this, right? But I'm saying if you look at what happens in court, and this is why it's so, this case gets really crazy, is the courts went in and they said, well, to the CRA reviewer, why do you think this should be refused? And the CRA reviewer was very candid. He said, look, if the client had answered any one of these questions, I probably would have given the claim. They couldn't answer a single question. So I was showing this to my engineers. They're like, oh, these guys got a patent, Dave. I need a patent. Maybe I'm not in there. I'm saying, wait. How would you have answered these questions? So they read these questions and they say, oh, well, okay, I have a new perspective. So these are the questions that the CRA reviewer asked. What was the experimental setup? Right? You spent a year doing the experiment. You're claiming you spent a year. What test specimens were used? How many specimens were tested? These are very valid questions. What were the test parameters? What temperature ranges were used? What loading procedure was used? Was foam injected, then temperature measures taken? Anyways, as you go through here, and the bottom one is probably the best, this is really a great question. This is the question I would ask. As it was a composite system, even thermal rise would produce substantial stresses. He was trying to help the guy. He's saying, tell me about this, because this is what would, if you can answer this, I agree it's SR&ED, but it seems like you went right to the final solution. You nailed it, bam, and you didn't do any experimentation whatsoever. So when the engineers read this, they sit there and say, well, oh my God, this is engineering 101, Dave. If I didn't do that, never mind shred claim, I'd expect my boss to fire me. Like, man, this is really bad to even think of doing an SR&ED claim on something like this. It gets even better, though, to show you how much the tax courts are willing to help the little guy. These guys don't give up. They get killed at Tax Court of Canada, but decide, we're going to appeal to the Federal Court of Appeal. Like, oh, man, this just gets better and better. Now, going back here, what happened between the Tax Court of Canada and the Federal Court of Appeal is the technical person, the engineer, who's one of the partners, dies. He kicks the bucket. He's buried. The financial partner swears under oath under the Federal Court of Appeal, swears on the Bible that there's all kinds of experiments. They're probably in this guy's attic somewhere, and now that he's dead, they just can't find it. My question was, well, why wouldn't you have brought any of that to the original, the case a year earlier, if they really did exist? And again, the tax court judge said that on the basis of the facts and sworn testimony, he was going to give the taxpayer the benefit of the doubt, so they got their $138,000. Okay? And I don't know what lessons we can take from this, but I always tell my clients, you don't want to have to go to that extent to get your shred credits. We'll just do it right the first way. A little bit of shred humor in there. If you knew the consultant, this guy Ed Littlejohn, he's retired now. I mean, he's a very old guy even at that time. I'm sure he's in the 70s, but just his methodology, it didn't surprise me at all. When I read this case, I just chuckled and shook my head. Okay, R.J. Miller is one where not a huge case. I believe the guy there was developing some kind of shotgun parts, and the problem was he goes into court and he says this: we started with one gun, I took the parts, I designed the piece, I built it, tested it, it worked from the first go, no changes were required. Okay? So it was a great idea, again. And what people were saying is, it's new, it's innovative, it's novel, it hasn't existed before, and they just don't understand the tax credit system. And they had bad advice, that if there's no experimentation, kind of like the IRS says, they say, we'll make it clear. If you didn't experiment with alternatives, don't even bother trying. Don't argue scientific uncertainty, kind of like what Thomas Edison did. He wouldn't qualify. He nailed it on the first try, even though it was pure scientific uncertainty. That would work up here, but IRS is saying, don't even bother claiming those, because those are such weak projects, we don't even want to deal with that. Chances are it's routine engineering. There may be the odd aberration, like a phonograph, but typically not, is what they're saying. Okay. Blue Wave Seafoods is one where the science officer comes in, they provide all this documentation, 580 different pages of documentation, or 580 documents, we're told, and the CRA reviewer decides they're not going to give them the claim, There's no technological advancement, no systematic investigation, and so forth. And then they challenge the science officer's opinion, saying, well, you're not even qualified in our field of science. And the judge comes back and says, basically, if you want to challenge the science officer's opinion, you should do it before they render the judgment. Okay, so when they announce the science officer coming in, you should question whether they're appropriate criteria and refuse them up front, versus after they render a negative opinion, which of course you're going to be biased that they don't have the right credentials. Now, having said that, has anyone ever tried to get the science officer changed? When you say up front, hey, I don't want this guy coming out because I don't think it's the right guy, and they say, tough luck, that's the guy that you're stuck with. So I'm saying it's not always that easy to request a change in science officers unless you can be very specific as to why. So even though the judge mentions that, the best thing is to document it in writing that you asked for that, go through with the joker that they send out, and then deal with it on the fly depending on what happens. Here's another one where the taxpayers in hardware and software. And really what they talk about here is understanding the constraints of the project. So ultimately what happens is they see that the project objective is to design a system to register 100% of applied loads. So if you pick up 1,000 pounds, 1% of applied load would be 10 pounds. They're trying to argue that in developing this system, the uncertainties are mechanical and software. And the key thing is that the judge says that although the appellant listed a number of factors which could affect the weighing accuracy, they're saying, hey, they did indicate variables that they could have experimented with, which could have created. So the judge comments, we're almost there. He said, despite that they did identify some variables, none of the documents they submitted indicated any formulation of a hypothesis or testing of those variables. So in other words, they knew what the problems were, but they didn't actually investigate any of the stated problems of uncertainty or have evidence that they did. So again, this was really one of lack of documentation. But they probably did know what the relevant things were, but they didn't keep any evidence that they actually did reasonable experiments or reasonable levels of experiments with that. And had they been able to provide that, they probably would have won. All right? Oh, and the last of our technical ones, a very recent case. So we're talking about those informal procedures now. This is one that came out in September of this year. This client's actually a dentist, University of Toronto professor. Of our technical ones, a very recent case. So we're talking about those informal procedures now. This is one that came out in September of this year. This client's actually a dentist, University of Toronto professor, PhD, and a dentist. And they do research, and actually it's funny because some of my clients are colleagues of the same group, so they do very similar kind of research to what's happening here. What happened here is that the client was arguably a world leader in what he does, has a system to monitor dental implants. So we're told that over the last 20 years he's done 12 or 13,000 dental implants, and he monitors using a software called Triton system that can monitor 200 different variables about the performance of a tooth. He's said to use about 50 to 60 of them. And he looks at those variables to try to determine what makes a tooth more successful or less successful than another scenario, right? It could be age, it could be bone density, it could be any number of these variables, which are all great scientific variables. So very similar to what my clients do, and it's almost always eligible. Okay? Very strong science, very hard to refute that. His problem was he had no evidence whatsoever. When they showed up in court, his only evidence was that he claimed he spent every Friday dealing with hypothesis and understanding the relation to those variables. And the judge asked him for evidence. The only evidence that he had for his 2007 and 2008 taxation years was an article that he published in a journal in 2007. And the judge said, well, it's good that there's conclusions in there that indicate you probably did this stuff, but that's not the actual evidence of you doing the stuff. And furthermore, the 2007 at best could help support what you did in 2007, probably 2006. Certainly can't you be used to support what you did in 2008. And she said, do you have anything? Like you spent every Friday. Do you have a notebook of what your hypotheses were? Do you have any notes, email, anything? They'll take stuff written on the back of a napkin that says you're looking at some hypothesis about how those combination of variables work. And he provided nothing. Now, when I talked to the representative, one of my colleagues, Julie, she mentioned that part of it was her fault, that we were talking about this case ahead of time. I'm the one who recommended that she went to the informal rather than general procedure. We'd still be waiting another 2 years. She didn't realize that when you went to court, you have an informal appeal, unlike general, you have to bring all your evidence with you there, because they're going to make a ruling that day. They're not going to reschedule. You didn't bring something, let's come back in 3 months. They're going to make that ruling right there. And she mentioned that he probably did have evidence, but they didn't have it there, so they kind of got baked. All right? So again, understand, especially if you're going to go to a formal appeal, come there ready to go. Don't be missing anything. If you don't think you have a strong case, don't bother. All right? Why don't we take a quick break there, however many minutes you guys want, say